So a quick recap to see just how far you've come now in this course. We've covered part 1, which was the preliminary part. So you know what the objectives of the Act are. We talked about that right at the beginning. It's all now about minimising and eliminating risks. It's about consultation and issue resolution, and promoting improvements in practices and assisting the duty holders to achieve healthier and safer work environments. It's about promoting advice and information education and training through the regulators and how those regulators can secure compliance. Also, how those regulators can review people who exercise the powers of the PCBUs. It's all about continual improvement and always aiming to keep improving for higher standards. It's now since 2008 about harmonising, so all of the states and territories have mirrored structures for their acts, and that way there's a consistent national approach. And most importantly, the Acts now not only deal with protecting people from injuries and fatalities, but also with illnesses and diseases, physical and psychological. So harassment and stress associated with that harassment is recognised now as leading to health problems. And work duties with higher psychological risks. So that might include, the post-traumatic stress effects of armed hold-ups or assaults on workers. And even right down to inappropriate shifts or roster arrangements and excessive workload. So those types of organisational factors are now covered. We've looked at the definition, so some of the terms and what they mean. PCBU instead of employer now, worker instead of employee, and the extent of the workplace, not just being on the work site, but any place that the work activity is conducted. We've outlined and defined risk and hazard. We've defined welfare, so that's providing such things as first aid rooms, toilets, washrooms, staff rooms on the work site. And plant is the general term used for machinery, equipment, tools and appliances. We spent a lot of time in this unit looking at the health and safety duties. So we've got the PCBU, we've got the officers, we've got the workers, we've got the visitors and customers, and also the role of the contractors. We will cover incident notification and flesh that out and elaborate on that in a later part of the course. Part 4 deals with authorisations, and some work needs to be authorised. So that's when there's licences, permits or registrations that are required. So for example, if asbestos had to be removed from a workplace, there's certain authorisations around that, also for operating cranes or forklifts. Part 5 we'll also be talking about later in this course, because there's a whole unit around workplace health and safety committees and their safety representatives and the whole process of consultation. Part 6 deals with protecting workers and their representatives when they exercise their powers or functions under the Act. So a person can't engage in discriminatory conduct for a prohibited reason, where that reason was the dominant reason for the conduct. So it sort of sounds quite swings and roundabouts, doesn't it? But basically, you can't discriminate against anybody that's exercising their rights to raise a hazard or raise an issue, a safety issue in the workplace. Also, the Act prohibits coercion and inducement. So, they can't be tempting somebody else to exercise or not exercise their powers or functions. So, for example, there can't be any favours offered to a regulator to then not exercise their powers to enforce legislation. We've definitely covered Part 7 with the union officers, the workplace health and safety entry permit holders. We've talked about Part 8, the regulator and the roles. Now Part 9, with this securing compliance, this is now more to do with the regulators. And these are the inspectors who are employees of the regulator, and they have a number of important functions and powers. So they can provide information and advice, they can assist in the resolution of the safety issues at work, and they can review disputes. They can issue notices, investigate the contraventions and assist with prosecution. They can also attend coronial inquests, so this is where there might be a work-related death, and they're able to examine the witnesses. Now the difference between a union officer and a regulator's inspector is, with the right of entry, an inspector can enter a workplace without consent and without prior notice. However, the inspector may enter the workplace if the entry is authorised by a search warrant. When that occurs, the inspector can then inspect, examine and make inquiries of anything, including a document at the workplace. They can bring any measuring equipment that might be required and conduct tests, make sketches or recordings. And the recordings can include photographs, films, audio, visual, digital or other recordings. They can take samples for analysis and ask people in the workplace to give some help in conducting those inspections. They can interview people, and a person is not excused from answering a question or providing information or documentation on the ground that the answer to the question or that documentation may incriminate that person. So they have to actually answer the questions. However, such answers that might incriminate them are not admissible as evidence against that worker in a civil or criminal proceeding. And the inspector must warn the person of this requirement beforehand. Now there's hefty penalties for threatening or obstructing inspectors. For each individual, it's up to $50,000 or 2 years imprisonment or both. And in the case of a body corporate, up to $25,000. And this is where Section 10, the enforcement measures, come in. The inspectors can issue improvement notices, prohibition notices, non-disturbance notices. And if a notice is issued, your workplace, as soon as possible, has to display a copy of that notice in a prominent position where the work is being carried out, the offending work. And if the workplace fails to do that, there can be some court injunctions there. Now, Part 11 deals with enforceable undertaking. So to avoid court action, that is to avoid court in anything but serious cases, which will automatically go to court, offenders can, with the regulator's approval, carry out the undertakings, usually some sort of initiative, safety initiative that will benefit the workplace. Or they might carry out an undertaking of a safety initiative that could benefit the industry or society, a type of community service. 12 and 13 deal more with those types of decisions and legal proceedings. And 14 deals with the provisions for making codes of practice and regulations. And we've certainly covered a lot of the more general codes of practice in this course.